of 1985. Her disappearance wasn't actually recorded until very early in the 1990s, when my grandfather was then investigating following almost £1 million insurance fraud. My grandfather was then convicted in 1996 for her murder.
Gosh, I mean, it's just an awful thing to happen in a family. But then, of course, your grandfather became eligible for parole in 2012 and then was released last month. Am I correct in thinking that you had no involvement at all in that process?
Pretty much. We had very, very limited. Any victim that ultimately is going through this process has an entitlement to be able to submit a victim impact statement. Unfortunately, the parole board itself operates as very much its own separate entity. So in terms of a victim, they have very, very little input into the whole process. Being completely frank, it's more for a tick box exercise in terms of for them to say that we have listened to the concerns of the victim. And that would usually impact in terms of the licence conditions that would then be imposed on an offender following their release, rather than taking into consideration the risk that they pose currently and in the future.
Well, what sort of impact has that had on you and your family, the fact that he now has his freedom, he's now been released?
Yeah, certainly. I think it's really, really difficult. If we were to go back through the timeline, I was 3 when my grandfather was originally investigated for the life insurance fraud. I was 6 when he was first convicted. I was 14 when he was reconvicted of the murder. We were the first family in British legal history to convict the same murder twice for without body. In 2014, I was 26 and started campaigning for Helens Law and changes in the process. So, in terms of finding out now that he's now been released, do I feel it's a bit of a slap in the face? Absolutely. It's been absolutely brutal, the process that we've endured as a family. And where we're at now is that we have no control, right? So, what we were hoping is that we would, it would be very much a carrot and a stick approach. Russell, you can have your freedom, you give us closure, you enable us to close this chapter of the book and be able to move on with our lives. And simply that can't happen. It sends out a message, a shockwave through the system. Quite frankly, offenders, killers can sit behind bars, and prison is nothing more than a clock-watching exercise.
So a slap in the face. And, of course, your grandfather has never revealed the whereabouts of your grandmother.
That's correct. He's been very, very cruel. And, anybody that's followed our story, who's watched The Investigator, British crime story, will be able to see for themselves that, Russell has made several accounts over the last 6 years. So since, becoming eligible in 2012, having his first parole hearing in 2014, he confessed to burning my grandmother over a period of 3 days. He maintained that account for 2 years before retracting it and saying that he buried her actually in a beautiful and idyllic location, but would not give us the location. He then retracted that 2 months later and said that he was a complete miscarriage of justice and that he's never committed murder. And he maintained that from 2017 all the way up until the 19th of June 2020, when my grandfather reverted back to his first ever confession and said that he had burnt her over a period of 3 days, but hadn't been involved in the murder itself and had blamed that on a third party.
Gosh, I mean, this whole thing just sounds so harrowing and so traumatic. We should also mention, though, there is this new law, isn't there, called Helens Law, which for the first time makes it actually a legal requirement for the parole board to consider if an offender is withholding any information, for example, like your grandmother's body, and they must take that into account when they're making that decision about releasing an offender. I mean, how does that play into this narrative?
Ultimately, they will take that into consideration. But that's actually something which they've been taking into consideration since 2016 and what's referred to as Chapter 9 within the Parole Board Members' Handbook. So it's already in process and the spirit of the law has been applied on several occasions. And quite simply, even with this piece of legislation going through Parliament at the moment, it will not stop killers from being released. A decision to release is purely based on risk and not morality. So what you and I would consider to be, unacceptable, the parole board deems to be acceptable. And I think that this is why it's really, really important that we do have open and transparent parole hearings, so there's proper scrutiny, and that the parole board, as well as the members of the public, can understand, how the system operates and how victims like ourselves are treated by the establishment.
And you mentioned there that openness, and these proposals will allow more of that in these parole decisions. What exactly then do you think needs to change?
Then there absolutely, what we've seen following the War Boys inquiry is that there was calls for greater transparency. There was a reconsideration process that was ultimately enabled for victims as well as prisoners as well to challenge decisions that are being made by the parole board. I always describe the parole process as a bit like playing a game of chess across two boards with your hands tied behind your back, blindfolded. It's damn near impossible to actually be successful in having a successful reconsideration. So that element of that transparency will enable victims like myself to be able to successfully, hopefully, challenge parole hearings, but also prisoners as well. And for the public and the media, it's really important that the media play a part in this and can really see exactly for themselves how victims and prisoners are treated and justify that cost and that expense to the taxpayer.
Well, Neil Gillingham, thank you so much for sharing.